to the Money RX for CRNAs podcast, where you go behind the scenes with host Brett Fellows, CFP, as he explores the unique opportunities and challenges facing certified registered nurse anesthetists along the path to financial independence. In each episode, Brett shares expert insights and actionable advice, equipping you with the tools you need to take control of your financial destiny and retire on your terms. And now, here's your host, Brett Fellows.
Welcome to Money RX for CRNAs. One of the great things about hosting this type of show is that we often will get questions sent to us from listeners. And we recently received one from a CRNA asking if I'd talk about estate planning. What exactly does estate planning mean, and why is it important? Now, I know this isn't a fun topic to talk about, but it is a great question and definitely a major pillar of any financial plan. So let's spend this episode answering the question, what is an estate plan and why do I need one as a CRNA? From a personal finance perspective, there are many ways to give. We typically think of charities. However, estate planning is a form of giving by which we outline what will happen to our assets after we die, perhaps leaving them to family, a loved one, or a charitable cause. But we can also give gifts in our lifetime. We certainly don't have to wait until we die. And I like this type of giving, as you get to see the blessing of your gift on the recipient and feel the benefits of giving in your own heart. We can also give our time. As with money, it does not have to be given to a charity. We can give our time by helping anyone in any way we can, which in turn helps us feel connected to those around us. If you do give financially, let's say to a charity, the best gifts are donations that matter to you, that can lower your tax bill, and that do not take away from the necessary saving and investing you're doing to reach your financial goals. Now, on the other side of giving is receiving. Inheriting money is not always as easy as it sounds. And while receiving an inheritance can solve financial problems, many people feel negative emotions about receiving a large sum of money. What may seem like a blessing to one can feel unearned or even oppressive to another. Additionally, those receiving inheritances after someone dies would often rather have the loved one than the money. Therefore, estate planning needs to be done thoughtfully and fairly to achieve your desired outcomes. It always helps to think of results first. This will help you create the best path for your money to pass to the next generation. Estate plans ensure that final wishes are honored and that loved ones are provided for after a person dies. The estate plan determines what becomes of their personal property and the financial assets they owned. The process involves a will and sometimes a trust and answers important questions like who gets what, how much tax will be paid, and who will have custody of minor children. And while insurance policies and retirement accounts are included in your estate for estate tax purposes, the beneficiaries of these plans and accounts must be named outside of your will. Therefore, you will want to ensure that your beneficiaries are up to date, since whoever is named beneficiary on these accounts or policies will receive your assets when you die. Okay, so who needs an estate plan? Well, I would answer that question as anyone with a spouse or domestic partner, minor children, or dependents who are not children, such as an elderly parent or special needs family members who cannot handle money. You'll also need a plan for your estate if you have substantial assets and specific items that you want to go to specific people. or if you have charitable objectives or issues that need to be dealt with after your death. These issues can be unrelated people you want to provide for, like a life partner or pets, business interests, or problem family members who may contest your will. Now, if all you own is a checking account and a retirement account with a named beneficiary, well, then I would say you don't need an estate plan. You can save your money for the day when you have more complicated planning needs. Children, especially minor children, present another set of estate planning needs. If you and your spouse die in a car accident together, who will take care of your children? Well, without a will and a listed guardian, the court will appoint one on your behalf. Now, this may be fine if you have one sibling and had already intended for them to be the guardian, but it can be problematic when all siblings on both sides of the family start fighting over your children. Unfortunately, I have seen it get ugly after loved ones pass. People can be very funny about money. The best way to avoid this ugliness after your own demise is to create a detailed estate plan. And the more specific you can be about who gets what, the less fighting there will be. And I wish it were not like this. However, planning can help avoid the unfortunate realities of property disputes. When creating an estate plan, you have to think about what is the result you want to achieve. What is the feeling you want to have now about your estate after your death? Too often, people drag their feet in regards to estate planning because it is hard to get excited about a topic that has to do with your own death. But again, I encourage you to think about the results rather than the process. Wouldn't it feel great to know you had a plan in place to protect your children and spouse if something happened to you? Acting now is better than the alternative, which is leaving your family to pick up the pieces after you die or become incapacitated. It is easy to modify an estate plan should your circumstances change, and therefore it is better to create one now, even if you don't have all the answers. And an important but less obvious reason to plan is that an estate plan is not just about the people you love and care about. It's also about you. It is your legacy and gives you control over what happens after your death. For that reason, it is very powerful. If an estate consists of all of an individual's financial assets, probate is the process that determines how those assets are transferred to beneficiaries upon death. Probate will confirm whether any will and testament is legal and ensure that the deceased person's intentions are carried out. Probate can also happen when there is no will. A probate court decides how to distribute the items in the estate. Now, probates can take just a few weeks for small estates and several years for large, complicated estates with poorly made plans of succession. Anyone with a valid claim to any assets can drag the process out by contesting the will or filing a petition with the probate court. A will can help guide probate, but it does not preclude the process from happening. However, there are some assets that do not go through probate. For instance, retirement funds and life insurance policies with payable on death beneficiaries are transferred upon the owner's death and do not go through probate. Assets in a trust are governed by the terms of the trust and are not subject to the verdicts of a probate court. For that reason, many financial planners and estate attorneys like to recommend that everyone have a revocable trust. My opinion is that trusts need to be considered on a case-by-case basis. And you'll also want to consider the taxes that need to be paid when the estate passes to others after your death. So using estate planning devices like trusts can help to minimize estate taxes and other costs for beneficiaries. And again, if you are single or your life is simple, then you probably do not need elaborate estate planning. Likewise, if you're young and have not yet accumulated a significant net worth, well, there's probably no need to spend the money on a plan just yet. If you have assets in a taxable account or a bank account and don't need estate planning, you can add what's called a transfer on death clause to your account. This will immediately transfer assets to a designated beneficiary if you die without the need for probate. I typically suggest that when a person gets married and is hoping to start a family or has substantial assets, then it is time to meet with an estate planner to learn the basic structure of planning an estate and discuss what laws apply where they live. And I can almost guarantee you may not have thought about it in these terms, but meeting with an estate attorney can be a great experience. It gives you a safe space to discuss what life would look like after you're gone, a subject not often discussed in everyday conversation, right? But you have a chance to create your legacy and feel what it would be like after you die. What do you want for everything you've worked so hard to create? When my wife and I met with our attorney, it was the best. We asked so many questions. We shared the dark thoughts that were on our minds, and we collaborated to create a vision of what it would be like after we died. We listened to our attorney tell us about standard practices and other couples he had just seen like us. And then we made the best decisions we could with the information that we had. I remember feeling exhilarated after signing our documents, knowing we had developed the best possible plan for our family. So that's an overview of the why behind having an estate plan and who should have one. Now, let's talk about the what an estate plan is. What are the different documents and what do they mean? Okay, so the core documents typically included in an estate plan are a last will and testament, possibly a revocable living trust, which I'll talk more about later, a living will, a durable power of attorney, a healthcare power of attorney, and a HIPAA authorization. Now, there are some individuals who have a more complex situation or an extremely high net worth and will also make use of additional things such as trusts. But I'm not going to go into that level of detail today, and you'll definitely fall asleep if I did. So this is our foundation. And let's start with the last will and testament. This is what we commonly think of when you hear the word a will. It's a document that outlines how you want your assets and property to be distributed after your death. It also allows you to appoint a guardian for any minor children. So a will is kind of a keystone or important part of a comprehensive estate plan. In a will, you can specify things like who you want to inherit specific assets such as a home, a car, personal belongings, bank accounts, etc. You can also specify who you want to serve as the executor of your estate. An executor is the person who will be responsible for carrying out the terms of your will and overseeing the distribution of your assets. Now, it is important to note that a will does not take effect until after your death has occurred. So you can make changes to it any time while you're living, as long as you are mentally able to do so and have the capacity to do so. Generally, a will has to be signed and witnessed according to the laws of your state, and we'll talk about that more later this episode. So that's a last will and testament. The next document is a living will. A living will is also known as an advanced healthcare directive or healthcare proxy. And this document outlines your wishes for medical treatment if you're unable to make decisions for yourself. Now, this can include decisions about treatment, pain management, medical care, life-sustaining treatment, What types of treatment might you want to sustain your life under various tragic circumstances? And a living will generally go into effect when your doctor determines that you're unable to make decisions for yourself. Perhaps you're unconscious or in a coma. You're incapacitated enough to a point where the living will serves as a guide for your doctors and loved ones who can make decisions about your medical care based on your wishes expressed in that living will. And just like other legal documents, a living will needs to be properly executed according to the laws in your state. The next document is a durable power of attorney. So a durable power of attorney is a document that allows you to appoint someone to manage your financial affairs if you're unable to do so yourself. The person appointed is known as the agent or attorney in fact, and they can make decisions about your assets and property, pay your bills, and other financial matters on your behalf. Power of attorney generally does not go into effect until your doctor determines if you're unable to make decisions for yourself because, again, you're incapacitated in some fashion. And there's more than one type of power of attorney. The durable power of attorney takes effect immediately. There's also another type called springing power of attorney, and this type goes into effect when it's determined that you're incapacitated. And like anything else, there are pros and cons to each. Generally, I mostly see durable power of attorney. It really depends on your preference, but I want your takeaway to be that there are different types of power of attorney. Next is healthcare power of attorney. This is also known as healthcare proxy or medical power of attorney. This document allows you to appoint someone to make decisions about your medical care if you're unable to do so. That person knows your healthcare proxy, and they're responsible for making decisions about your medical treatment based on your wishes and best interest. This too goes into effect when your doctor says you can't make decisions by yourself. This person or agent will then step in and make decisions about your treatment, pain management, and other medical care. And you can also place limitations and restrictions on the agent's powers as well. So things can be customized, still based on your desires. Next, we have HIPAA authorization. HIPAA authorization allows you to determine who can have access to your protected health information, your medical records. Under HIPAA, healthcare providers are required to keep your personal health information confidential unless you specifically authorize them to share it with certain individuals. Now, a lot of people think that a spouse or a family member automatically has access to your medical records by nature of their relationship to you, but it's actually not the case. Sometimes medical providers will refuse to share medical information even with a spouse or family member because they don't have explicit HIPAA authorization. So having this documented will streamline the process of sharing your medical records with those who would like to have the access. Okay, I said we'd come back to this. A revocable living trust. This is something that is sometimes part of these estate planning documents. Not always, but sometimes. So a revocable living trust is a type of trust that lets you manage your assets and property during your lifetime and specify how you want your assets to be distributed after your death. Now, it's called a living trust because it's created and funded during your lifetime, as opposed to a trust which is created and funded upon your death through your will. And it's also called revocable because you can make changes at any time. You can terminate it, you can update it, you can replace it. All of those things can happen during your lifetime, and that's what makes it revocable. In these trusts, you're called the grantor of the trust, meaning you're the person who creates the trust and transfers assets into it. You'll also, while you're living, serve as the trustee of the trust. So after your death, the assets of the trust will be distributed according to the terms of the trust, specified by you in the trust document. So this means you can specify exactly who you want to inherit assets, how you want assets to be distributed, without the need for probate court. And that is one of the advantages of a trust. It bypasses probate. Now again, probate is the legal process by which the court oversees the distribution of a deceased person's asset. This can be time-consuming and very costly. Sometimes it can take months or even years to go through probate. Now, I talked about how the trust will distribute assets as per your wishes. But what's great about a trust is its flexibility and ability to be customized. For example, if you want to specify that after your passing, your minor children only have access to certain parts of your estate, or maybe a certain portion of your estate, or assets until they reach a certain age, so you can have things very finely tuned and flexible in a trust. You can't do this in a will. But like everything else, there are also some downsides to a trust, and one is complexity. It is a more complex legal instrument to maintain and manage. You have to transfer assets into the trust. It is more expensive to create and just a more complicated instrument. And there you have it. Those are the basic estate documents. And to review those again, last will and testament, and possibly combined with a revocable living trust, a living will, durable power of attorney, healthcare power of attorney, and HIPAA authorization. Now, how do you get these documents created? Well, there are actually a few ways to do this. The ideal way is to talk to an estate planning attorney. This will be the most expensive route, but you will get customized professional advice. So talking with an estate attorney is the ideal situation. The next best thing, I think, is using an online service. There are a number of online service providers that will do these online for a low fee. And generally within less than an hour, create a set of estate documents by answering questions and going through a process. And it will generate the right estate documents for your particular state. And you can imagine in 2024, these services have come a long way. They're actually pretty valuable, so I do recommend them to clients quite a bit. Now, full disclosure, I have no affiliation with this one, but trustandwill.com is a website that I have seen many of our clients use and be happy with. Next is, how do you execute estate documents? How do you make sure that they're valid? Well, the first step is you have to sign those documents, and in most states, that signature will need to be notarized and possibly witnessed as well. The attorney or the online service you use will guide you through the process for your particular state. You want to, of course, store them safely. I recommend putting your estate documents in a fireproof safe in your home. Those are the originals. And then I like to scan the executed copies with notarizations on them and file them online somewhere in a secure cloud system. We actually do this as a service for our clients and save all of their tax and estate documents in a secure online vault. And there you have it. Those are the estate documents everyone should have. More complex estate situations will have more complex and other instruments, but everyone should really have those core set of documents. They make life easier for loved ones when you pass. Estate planning, I think, is more of an act of love than anything else. It shows love for the people that you would leave behind if you were to pass, and it helps streamline that situation. It helps lower their anxiety. It helps lower their stress at a time where they are already going to be stressed by your passing emotionally. This is something you do because you love those people who you leave behind. It's a way of taking care of them, making sure they're provided for even after you're gone. And so I hope that helps you get a sense of what these estate documents actually do and why they're so important. Now, some actions you can take today. Number 1, choose your beneficiaries and designate them on any retirement accounts or insurance policies that you already have. Generally, people will pick their spouse as their primary beneficiary, And if they don't have children, they then have a difficult time picking the secondary beneficiary or the contingent beneficiary. And even if you have young children, you will want to consider an adult as your contingent or secondary beneficiary to take care of other parts of your estate plan, like being executor, guardian, power of attorney, or healthcare proxy on your behalf. Minor children cannot be any of these if you and your spouse die at the same time. And number 2, ask yourself these key questions. Who would you pick as an executor? This person needs to be organized and willing, etc. Who would you pick as guardian of your kids? This person should love your kids as if they were their own and raise them similarly to how you would. Who would you pick as a healthcare proxy? Choose someone in the family or a close friend who works in the medical field or has the ability to make decisions under lots of pressure. Who would you pick as power of attorney? This is usually the most financially responsible person you know and trust. Who would you pick as a trustee if you created a trust in your will? This is usually the same person you select to hold the power of attorney, but not always. What kind of legacy do you want to leave? You can choose anyone you like for any of these roles. I highly recommend considering all of these questions prior to creating an estate plan with an attorney. All right, let's wrap this up. I hope you found today's episode helpful as you think about your estate plan and where you are today and its importance and relevance. And again, given that everyone is different and everyone has unique needs and circumstances when it comes to estate planning, it's nearly impossible for me to cover everything. So if you have any unanswered questions about your will or how to list primary and contingent beneficiaries, or maybe you're curious about whether you need a revocable living trust, or maybe you just need a recommendation or a resource, well, please don't hesitate to reach out. You can shoot me a note. My direct email is brett@oakcapitaladvisor.com, or directly schedule time with me by going to our website, oakcapitaladvisor.com, and click the free pre-op assessment link where you can schedule a call with me at your convenience. And take a minute too to give this show a review on iTunes or wherever you listen to your podcasts. We'd really appreciate that, and that would make it easier for other CRNAs to find us when they're searching for podcasts. Thank you again for listening to this episode of Money RX for CRNAs, and have a great week.
This podcast is for informational and entertainment purposes only. It should not be relied upon as a basis for investment decisions. This podcast does not engage in rendering legal, financial, or other professional services.